Hello everyone. Hello everyone. Am I perfectly audible and visible to you all? फटाफट से मुझे comment box में बताओ ताकि we can start the video. Hello, hello, hello. Good evening, Adrija. Good evening. How have you been? Am I perfectly visible and audible? Good evening, Pranshi. Good evening. Chalo, let's start the video. We will be covering criminal law 2 today. We have covered almost all the subjects. Okay, so this is the second part that we'll be covering. फटाफट से फर्स्ट क्वेश्चन देख लेते हैं, which is on marital rape execution and constitutional debate. You guys will also read the question. I will also read the paragraph, and then we'll move towards the questions. ठीक है? तो I'll also read out loud. You read it whether you want to read it by yourself, and if you really want to focus, what I'm going to read. Okay. So the Indian Penal Code and now the Bharatiya Nyaya Sanhita, that is BNS, continues to retain the marital rape exception, which excludes sexual intercourse by a man with his wife above 18 years from the definition of rape. This provision, rooted in colonial era assumptions, has come under increasing constitutional scrutiny. In 2022, the Delhi High Court delivered a split verdict on the matter, with Justice Shakdher holding that the exception violates Article 14, 19, and 21 of the Constitution by denying married women equal protection of law, while Justice Hari Shankar upheld the provision, reasoning that it relates to the institution of marriage and policy choices best left to Parliament. The matter is now pending before the Supreme Court, which has in the past recognized the importance of sexual autonomy and dignity in cases like Navtej Singh Johar versus Union of India 2018 and Joseph Sain versus Union of India 2018. While supporters argue that consent within marriage must be respected as in any other relationship, opponents caution against potential misuse and disruption of marital stability. सबने पैराग्राफ रीड कर लिया? दोनों इंपॉर्टेंट है प्रांशी, स्टैटिक भी और करंट लीगल भी, दोनों ही इंपॉर्टेंट है. आप सबने पढ़ लिया? अब आगे बढ़ते हैं क्वेश्चंस की तरफ. लेट्स सी व्हाट इज आवर फर्स्ट क्वेश्चन. व्हिच कॉन्स्टिट्यूशनल प्रोविजन इज मोस्ट डायरेक्टली वायलेटेड इफ द मैरिटल रेप एक्सेप्शन denies equal protection of law to married women? Tell me the answer. Fatafat in the chat box. Tell me the answer. Question mark क्यों दे रहे हो अद्रिजा? Be very confident while you mark your answer. एक बार वापस से पैराग्राफ देखो. What are they talking about? To the new students, read the paragraph. I'm giving you 1 minute. Pranshi says A. Confirmed A. And in the caps. Chal. Yes, the answer would be A because they were talking about what? Equal protection of law, right? That's where the answer would be A. If the Supreme Court strikes down the marital rape exception while retaining the rest of the rape provisions, it would be applying which principle? Doctrine of severability, doctrine of proportionality, doctrine of eclipse, doctrine of prospective overruling. जल्दी जल्दी बताओ मेरे को. प्रांशी मैंने बताया क्रिमिनल का स्टैटिक पार्ट भी थोड़ा बहुत इंपॉर्टेंट है. ऐसे नहीं कि बहुत ज्यादा इंपॉर्टेंट है, बट यस ऑफ कोर्स इंपॉर्टेंट है. स्टैटिक हो लीगल का या फिर करंट हो, दोनों ही इंपॉर्टेंट है. आप किसी को भी छोड़ के नहीं जा सकते विद इन द रिस्पेक्ट टू द क्लैट एग्जामिनेशन. ठीक है. गिव मी द आंसर. किसी ने पूछा ही नहीं. डॉक्ट्रिन ऑफ सेवरेबिलिटी क्यों होगा चंद्रलेखा? Why it would be doctrine of severability? कोई आंसर नहीं कर रहा है. ओके. सो डॉक्ट्रिन ऑफ सेवरेबिलिटी मीन्स कि अगर मेरे पास दो क्लॉजेस थे जिसमें से एक क्लॉज वाज रिडंडेंट, सो आई कैन जस्ट फॉलो वन ऑफ द क्लॉज फ्रॉम दैट सेक्शन एंड लेट द अदर वन रिडंडेंट, और हम उसको हटा देते हैं. तो यस, डॉक्ट्रिन ऑफ सेवरेबिलिटी इज द वन थिंग दैट हैज बीन यूज्ड हियर. Which prior judgment of the Supreme Court is most relevant for recognizing that consent cannot be presumed merely due to a legal relationship? हमने बहुत सारे लैंडमार्क जजमेंट्स पढ़े हैं. हमारे पास बुकलेट्स के अंदर भी लैंडमार्क जजमेंट्स हैं. एग्जैक्टली exactly. तो वो सेव अलग कर दिया गया. सिंपल है थोड़ा सा. नहीं बच्चे, द आंसर वुड बी सी, इंडिपेंडेंट थॉट वर्सेस यूनियन ऑफ इंडिया, क्योंकि नवतेज सिंह जौहर talks about the transgender equality of transgenders and everything. Joseph Syme actually talks about, as far as I remember, it talks about striking down adultery. And independent thought versus Union of India talks about the marital rape of a minor wife. That's the answer would be C. And Menka Gandhi, we all know it talks about Article 21. She was seized and she was not allowed to travel anywhere. So Article 21. Exactly. B is adultery. C would be the answer. If the court refuses to intervene and instead defers the issue to parliament, it would primarily be upholding the principle of. What it would be holding? जल्दी यार, इजी है ये तो. Fourth का answer, separation of powers. Yes, it's a correct answer. It was very easy question. Now next paragraph, फटाफट read करो. It is on new criminal laws, भारतीय न्याय संहिता 2023. On July 1, 2024, India replaced the IPC, CRPC and Evidence Act with भारतीय न्याय संहिता, भारतीय नागरिक सुरक्षा संहिता and भारतीय साक्ष्य अधिनियम. While the government called these reforms a move to decolonize justice, critics have argued that several provisions continue colonial legacy in new forms. For instance, Section 103 BNS replaces the sedition law with a new offense, acts endangering the sovereignty, unity, and integrity of India. While this appears to modernize the law, free speech advocates argue that it remains vague and could still suppress dissent. Another notable reform is the express criminalization of mob lynching, prescribing severe punishment, including life imprisonment or death, depending on the gravity. At the same time, BNS has introduced community service as a new form of punishment for minor offenses, a step welcomed as progressive. The reforms reflect a balance between modernization and continuity, but legal scholars remain divided on whether these changes are truly transformative or merely cosmetic. The replacement of sedition with the new offense under Section 103 BNS most directly impacts which fundamental right? सी, राइट टू इक्वालिटी होगा नहीं, राइट टू लाइफ एंड पर्सनल लिबर्टी भी नहीं होगा. क्यों होगा सडिशन में? ठीक है, इट वुड बी ऑलवेज अबाउट स्पीच मेकिंग एंड प्रूविंग योर पॉइंट्स, स्पीच एंड एक्सप्रेशन. सडिशन वुड कम फॉर दैट. सो आंसर वुड बी इन आर्टिकल 19(1). ठीक है, एंड इट वोंट बी कमिंग फॉर प्रोटेक्शन इन केस ऑफ प्रिवेंटिव डिटेंशन. Second question, if Section 103 BNS is struck down for being vague, which doctrine would apply? Doctrine of severability, doctrine of proportionality, void of weakness, basic doctrine of structure. So doctrine of severability would be coming for the vagueness, is not about vagueness. We have already seen. Proportionality is about balancing restrictions and not vagueness. The answer would be C, void of vagueness. A vague law criminalizing acts endangering unity, which might risk misuse of unconstitutional. Basically, which is a unconstitutional part. Also, D is talking about basic structure. The answer would be C here in this scenario. Next question, if section, which of the following is a progressive reform introduced in BNS? Sedition punishment enhanced हुई थी. Removal of right to appeal was also not true. Criminalization of all defamation was also not there in BNS. ठीक है, तो yes, it was introduction of the community service. The answer would be B, where progressive reform aimed at restorative justices, right? Fourth question: which committee's recommendations played a major role in reforming India's criminal law, including ideas of sentencing reforms? वर्मा कमेटी तब बनी थी जब निर्भया वाली चीज हुई थी, दैट हैपेंड इन 2012. Shah Commission was formed basically for political inquiries. It was not for criminal justice again. Shri Krishna Committee was focused on Mumbai riots. So yes, it's Malimat Committee that came into picture in 2003. Next paragraph: death penalty and sentencing. The death penalty in India continues to be a subject of intense debate. While the Supreme Court in Bachchan Singh was a state of Punjab upheld its constitutionality, it limited its application to the rarest of rare cases. However, subsequent judgments have revealed inconsistencies in how this doctrine is applied. In Manoj versus State of Madhya Pradesh, the Supreme Court emphasized that sentencing must not be mechanical. Courts must consider mitigating factors such as socioeconomic background and mental health, age, and possibility of reform. Before awarding the death penalty, this approach reflects an evolving global trend towards humanizing criminal justice, even as India continues to retain capital punishment for heinous crimes like terrorism, rape of minors, and mob lynching leading to death. Opponents argue that death penalty is irreversible, prone to judicial error, and inconsistent with India's obligations under international covenants advocating abolition. Supporters, however, claim it acts as a deterrent and ensures justice for the victims in extreme cases. So, the first question would be: the principle that death penalty should be imposed only in the rarest of the rare case was laid down in. The answer is very simple, very simple. It's Bachchan Singh versus State of Punjab. The emphasis on considering socio-economic and psychological factors before awarding death penalty in Manoj 2022 reflects which constitutional value? Will it be Article 14, equality before law? No. Right to free speech? No. Right to life and personal liberty. We are talking about murder cases here, rarest of the rare case here. So, yes, it would be right to life and personal liberty. Answer would be C. If the legislature were to prescribe a mandatory death penalty for a specific offense, it would most likely violate doctrine of severability, principle of individualized sentencing under Section 21, right against self-incrimination under Article 23, separation of powers. जल्दी बताओ थर्ड का आंसर. द थर्ड का आंसर वुड बी बी. डॉक्ट्रिन ऑफ सेवरेबिलिटी यहाँ पे नहीं यूज होगा. राइट अगेंस्ट सेल्फ इंक्रिमिनेशन अंडर आर्टिकल 23 नहीं यूज होगा. सेपरेशन ऑफ पावर इज इररेलेवेंट. प्रिंसिपल ऑफ इंडिविजुअलाइज सेंटेंसिंग अंडर आर्टिकल 21 is the correct answer. Which international legal instrument most directly encourages abolition of the death penalty? UDHR talks about recognized right to life but does not abolish death penalty. Geneva Convention is talking about wartime, humanitarian laws, human rights के बारे में बात करेगा. UN Charter would always talk about general UN framework. So it would be ICCPR. Second option is the correct answer, which is like very much near to what we are talking about. Next, digital evidence and cybercrime under BSA 2023. The Bharatiya Saksh Adhiniyam 2023 has overhauled evidentiary rules, particularly with regard to electronic records. Section 61 BSA states that electronic records are admissible, provided that their integrity and authenticity are established. In a recent cyber fraud case, The prosecution relied heavily on WhatsApp chats, call recordings, and metadata to prove the accused involvement. The defense objected, arguing that without a Section 65B certificate, such evidence is inadmissible. This debate tracks back to the Supreme Court ruling in Anwar PV versus PK Bashi 2014, which held that a 65B certificate is mandatory, and subsequent clarifications in Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal 2020. The larger question remains as digital evidence becomes central in criminal trials. How should courts balance technological realities with safeguards against manipulation? The first question being which case established that a Section 65B certificate is mandatory for admissibility of electronic evidence? So while Shreya single case, we know that 66A was struck down under IT Act. Navjot Sandhu 2005 was a case where secondary evidence, even without 65B, was allowed. It was overruled later, but not before. Puttu Swami case is all about privacy and not evidence. So answer would be B. Anwar PV versus BK Bashir that they are talking about in the passage, right? Under BSA 2023, in admissibility of electronic evidence is specifically dealt with under Section 45 is about expert opinions, Section 89 is about presumptions, Section 10101 is about burden of proof, Section 61 of BSA deals with admissibility of electronic records. If digital evidence is challenged on grounds of possible tampering, which principle of criminal law protects the accused? Double jeopardy, presumption of innocence, doctrine of severability, res judicata. Double jeopardy, no second trial, severability, not relevant. Res judicata is civil law principle which is not relevant at all here. So answer would be presumption of innocence. Metadata in the context of digital evidence refers to primary text. It is all about content, not metadata. Also, certificate under 65B is different requirement. Testimony is not metadata itself. So the metadata, hidden data, time, device, location, all is there. It's background details of digital records. So metadata is. So the answer would be what? Ancillary data like time, device, and location details is the correct answer. That's it for today, and I really hope you have all are following Telegram channel, Instagram channel, and have already subscribed to our YouTube channel for more such videos. We'll be coming back soon with a similar video, and I really hope you are liking the video. Please like, share, and subscribe the video. We are in the last of the last months of our CLAT examination preparation. I really hope ये वीडियोस आप सबके लिए हेल्पफुल रहेंगे. बाय, टेक केयर.